Good morning, good afternoon, very warm greetings to everyone in the audience, and of course to our speaker, Justice Muanpawong. Very warm welcome to Durham, even if only virtually, and welcome to the second part of our Global Environmental Law lecture series. I'm delighted we had 6 really successful lectures already before Christmas, and now we are entering the second half. And I'm really grateful for the audience to stick with us, to be with us, and to have these discussions about how international environmental law is applied by courts, by leading courts around the world. So it's a real pleasure to have you here with us. And please, during the talk, if you have any questions, if you could type them into the Q&A or chat function, I will pick these questions up. I can also give you the allowance to speak. We can see how it goes, but if you'd rather have a question typed in, type it into the Q&A section, please. So just give a short introduction and then I hand over the floor to Justice Suntariya Muanpawong. So I'm really delighted again to have you here with us. Justice Suntariya Muanpawong is the Vice Chief Justice of the Court of Justice Region 5 of Thailand. She was previously the Secretary of the Environmental Law Division and Vice Secretary of the Supreme Court and Secretary of the Appeal Court Region 1. She received her Bachelor and Master of Law from Thammasat University and her Barrister at Law from Thai Bar Institute and the Master and Doctorate degree in Public Environmental Law from Münster University in Germany, which is not far away from Soest, where I've got close connections to. Before becoming a judge, she was a lawyer, a teacher in a Southeast Asian refugee camp, and a legal officer in the Harbour Department. Justice Suntariya was the first supervisor of the Judicial Research Institute, where she played a significant role in developing the accountability and responsiveness of the judiciary. She attended various human rights programs held by international institutions, and she has been a proponent of people-oriented justice reform and has conducted many research projects on justice reform, child rights protection, gender justice, prisoner rights, and environmental jurisprudence. She has been appointed to be a commissioner in the environmental legislation process. She's also joined many commissions and working groups to develop constitutional rights. So again, she's really connecting her professional life, the application of international environmental law, with making contribution to the wider discussion, but also to academia. And I'm really grateful for you to have chosen the topic of overlapping tensions among environmental, administrative, criminal, and civil law in Thailand. Thank you again very much. We're excited to hear your lecture. I hand the floor over to you. Thank you.
Thank you very much. Sawadee ka. Good morning, Professor Petra Minnerop. Good evening, Justice Preston. Good morning, everyone, every student. I really love to see you all this morning, but I cannot do it. So I hope next time I can visit the Durham University. You know, many Thai students studied there, and some of them became judges in our Court of Justice. So they worked very smartly, and I think I really appreciate that you can produce good lawyers to the world. So today I'm so honored to be invited from Professor Minnerop to join the Global Environmental Law in dialogue with the judiciary. So I try to find a topic to talk and share with you all. It seems to be difficult, you know, because I think Professor Minnerop is like an expert in international law, but I myself, I never learned much in international law, so I learned mostly public law. So I think I try to compare a little bit some ideas from international law and how can we implement in our domestic law. So I hope some information that I would like to share might be useful for you all today. So you can see my PowerPoint? Yeah, okay. So I chose the topic overlapping tensions among environmental law, especially the three legal instruments, administrative, criminal, and civil law in Thailand, because I found that if you want to be a good environmental lawyer, you need to know these three things, and you must use it so fluently and efficiently. And I think even many environmental lawyers in Thailand, so we cannot understand this well. So I chose this topic. The objective of the lecture is like the objective that you set from your global dialogue. So the aim of this lecture is to explore issues that are addressed in the international declarations and agreements, and to understand the developments that have taken place since these instruments were adopted, and how they played a role in the judicial practice of courts in Thailand. Learning from the normative framework of global environmental law from Thai perspectives and jurisdictions. And one question that I would like to ask you all, the students, from my starting point, if you are, or if you were the UNEP executive director, what would you do with all countries in the world to help the planet and also help the poor people? I think many rich people in some countries, but mostly we have many poor people around the world, and they struggle with the environmental conflicts. So if you were the UNEP executive director, what would you like to do? Yeah, so I want you to keep this question and try to answer me. You can type in the Q&A box. Yeah. So I'd like to show you the development of the environmental laws in the world. I think you have learned from your professors and from the guests already. However, I would like to show you my points of view. I don't think the UN or the UNEP was the first group who started talking about the environmental justice, because even in our country, you can see from the right hand side, Thai law. So we had navigation in Thai Water Act. That's mean we had Water Protection Act. See, I think more than 100 years already, So it started before the Stockholm Declaration. Yeah, and we had also like Canal Protection Act, or even the removal of Water Hyacinth Act, So I mean, every community, every country, they tried to develop their own system for the environmental justice. However, we have learned a lot from the international laws, and also we have learned and copied many laws from other countries. I don't know what we should use, copy or borrow, So it's mean that I think the UN or the UNEP, or maybe the IMO or UNODC, I think many international organizations try to develop the international standard of environmental law. However, many countries also, or other regions, though they try to develop their own norm. For example, the Thai law, the Thai lawyers have learned a lot about the US wildlife law. We learned that they have like Lazy Act, that the country can have like longhand jurisdiction over other countries, something like that. And we appreciate that also. And for example, the US EIA inspire us, and later, so we try to develop our own EIA law. So it means that not only the international law, but the domestic laws from some countries can inspire other countries to develop better legislation. Yeah, I'd like to talk first about our legal systems, and then I talk later about the jurisprudence. Yeah, we have had like many constitutions. I think until now maybe 20 constitutions. I think we have the most, not the biggest number. Yeah. However, I think we try to show the people and the world that we were concerned about the natural resources protection or the environmental protection. And that's mean before 1997, actually we had some constitutions stated or guarantee that the state must have the state determination to protect the environment. However, later, so we discuss a lot, should it be only the state determination, or should we transform this into the right of the people? So finally, 1997, so we decided that we should have the constitution that protected the environmental right. Yeah, so it means we constitutionalize the environmental right. Yeah, and so according to the Constitution of 1997, so we had like the right to natural resources, the right to healthy environment, and the right to participate. So it's mean the people can have access, could have access to information related to the large-scale project that would be proposed, and the right to be heard and right to sue. However, this first constitution did not write a lot in details. So there were many questions how these rights would be implemented. And so later, 10 years later, as we wrote again the constitution, so we try to give more detail. So we call this the detailed version. And later, 10 years later, so we have another new constitution, and this is the current constitution. These rights were shortened, so it's like the life of the people, sometimes we are bigger, and then we are thinner, something like that. So it's the law is like our lives. So so it's like when the government focus on the rights of the people, they try to expand and guarantee the rights, but if they are not so active enough, so they might cut your rights, So, however, I would like to show, I think this, the Constitution of 2007 is maybe the greenest constitution of Thailand, because after 10 years that we started talking about rights of the environmental rights, so later we try to give more detail. So I'd like to give you some ideas. So this is like in the chapter 3, Rights and Liberty of Thai People, part 12, Community Rights, section 66. So persons assembling as to be a community, local community, or traditional local community shall have the right to conserve and restore the custom, wisdom, and also have the right to exploit natural resources, the environment, and biological diversity in a balanced and sustainable fashion. This is important because we don't understand much about, it was firstly established, the right of the community. So the people did not understand well what's the meaning of the community's right. So I mean, so many court jurisprudence try to understand, try to interpret this provision. So, and also it's not only the right of the people or community to exploit the natural resources, but we had the right to participate with state and communities in preservation and exploitation of natural resources and biological diversity, and promote the quality of the environment. And another important provision is that any project which may seriously affect the quality of the environment, natural resources, and biological diversity shall not be permitted unless its impact on the quality of the environment and on health of the people in the communities have been studied and evaluated, and consultation with public. And we had the right of the community to sue if the government agency ignore this duty, you know. So this was like the people try hard to fight, you know, and try to apply this law. And some of them they won, some of them they cannot have success yet. However, we try to interpret and try to work and understand the concept of the constitution, because it's not so easy also about the community rights that we did not have before. Later, 10 years later, so when we had the coup, and the coup had set up the new constitution. So this is our current constitution of 2017. So section 57, the state shall, you know, actually the content or substance is not so different from the last one, but they change from the right of the people, you know, to the state has power to do and to protect instead of the people. So I think this is we are worried about this, because we think that this our right was decreased because of this new constitution. Okay, let me talk show you more about our main environmental protection law. Apart from the constitution, so we have had many legislations, and the most important one, I think, is the enhancement and conservation of the National Environmental Quality Act of 1975 and 1992. So we try to have like set up the system of the whole environmental management in this law, and from 1992, so we had the chapter 6 on civil liability. So, you know, this is very new to us, because in the past we might have only tort law or nuisance, private nuisance law, but this is like the civil liability, environmental liability. So I'd like to read a little bit. So section 96, so if leakage or dispersion of pollutants caused by or originated from a source of pollution is the cause of death, body harm, injury, or ill health of a person, or has caused damage in any manner to the property of the private person or of the state, the owner or possessors of such source shall be liable to pay compensation or damages therefore, regardless of whether such leakage or dispersion is a result of a willful or negligent act of an owner or possessor thereof. You know, so this is a very advanced provision, because from compared to the civil and commercial code that we have had, every tort delict, act, unlawful act. So when the people are liable to pay compensation, it means they must do something wrong or illegal. But from this provision, it means even they have no willful or negligent act, they must pay the compensation or damage. And the compensation or damages to which the owner or possessor of the source of pollution shall be liable according to paragraph 1 shall include all expenses actually incurred by the government for the cleanup of pollution that arose from the incidents such as leakage or contamination. Section 97 is also interesting, I think, because this provision states that any person who commits an unlawful act or omission by whatever means resulting in the destruction, loss, or damage to natural resources owned by the state or belonging to the public domain shall be liable to pay compensation to the state. Compensation shall represent the total value of natural resources destroyed, lost, or damaged by such an unlawful act or omission. So this, I think this was the first provision in our history that we recognize the natural values, you know. So it's like ecological damage must be concerned from this provision. I think Professor Minnerop might be interested in this point because you have done great things for the climate justice. And now we are trying to have the climate change view. So I would like to show you some ideas about our newest legislation. So Thailand is now drafting the law directly targeting climate change and its commitment to meet the Paris Agreement goals. So the kingdom has set a goal to reduce its carbon emissions by 20% by 2030. Thailand tries to be the leader in the Southeast Asia in power generated by wind and solar and is strong in other renewables. Its 20-year national strategy aims for higher tech and green economy and society. So the Office of the National Resources and Environmental Policy and Planning released a draft of Climate Change Act for public consultation already, actually 2 years ago or 3 years ago, and always in process, I think, because many people try to criticize. So even me, you know, because I think they have very low ambitions. I think so they change a little bit and try to develop the better one. So the National Climate Change Board will be established as a focal point for the policy development. The bill would require businesses and factories to report their greenhouse gas emissions and publish their carbon footprint to record and report their carbon emissions. And the government will require companies making products of export to have labels on their products detailing their carbon footprint information. So I think that we believe that this law should help the country work in line with the global action to reduce global warming. However, as Thailand, the government has started, so I think there were some controversial discussions and, you know, many people ask whether we have enough size and technique, appropriate technique to tackle with this problem, or when should we have like more mitigation or adaptation measures, something like that. And when our office started the carbon credit or carbon trade, so many questions from the community, local communities, and some criticize already that the things that they have done is like greenwash, something like that. So there's many conflicts also about climate change policy. However, I will not talk about this in detail. So maybe my main point that I would like to share for you today is the development of the environmental law instruments, and mostly so they are overlapping. Actually, we did not started with the administrative measures because in the past we don't know much about public law. We had only civil law and criminal law. So I think as I told you, so we had we created some canal protection acts or water protection act. So we focus on the criminal law. So if if the people violate create some pollution, something like that, so they must be criminalized or must be punished. And so in the past we might have only small things, small problems, but right now we started already to talk about environmental crime or ecological crime. And I think according to the international rules on human rights and business, so we now talk a lot about the corporate crime and environment. Yeah, so I think criminal law always plays a significant role in our legal system. And about the civil law measure, so I think next year we will celebrate the 100 year of the civil code. We copy the German through the Japanese system. So we will celebrate this, and we had tort law already or nuisance law. And it's private against private. So when they had problems, so we apply the tort law, and yeah, and normally it's compensation for the personal injury. And later, as you can see, we had since I think more than 40 years already that we had the law guarantee the ecological damage. So, but we just apply this law in practice, just some case law maybe in last 20 years, although the law was older. Yeah. So we developed the civil law measures, including the ecological damage or the how to demolish the encroachment or chase away the trespass or intruders in the public land, and we talk about the restoration or remediation. Yeah, and I think the newest measure was the administrative law instrument. So actually, the administrative law it's the preventive measure, precautionary measure. For example, the zoning process or the EIA process, people participation or the permission process. All things are the important tools that we can stop the violation of the violation beforehand. And all these things are very new to us, and we try to learn from your experience from the UK, from the US, or from Germany. For example, in Germany, you have Administrative Procedure Act. We copy some sections, some parts of your German law, but the most important part about the people participation, the Bürgerbeteiligung, people participation chapters, we did not copy that, and we said that my professors, I think many people who did this law, they say that these are too difficult for Thai people, and we cannot implement it this well. So we stop and let us later amend our law, and until now nothing changed. So we try to learn from other jurisdictions, and we try to develop. And however, finally we have these three tools: criminal law, civil law, and administrative law. Do you think our Thai lawyers are ready to use our weapons in one hand, in our hands, because we have like 3 swords, yeah. And how can we use this well, proportionately or properly? This is a big question, because sometimes it's like you can separate your work, but sometimes the work is overlapping, and how can we work well? How can we prioritize which kind of weapon that we choose to use first? This is the question that we are raising, or some people did not understand which question should be raised. Yeah. So from this you can see. Before I talk more in details about each weapon, so I think I show you a little bit more about our environmental protection agencies. So like other countries, so we have like environmental agencies, we have National Environmental Board, National Pollution Control Board, many national boards, and also, we have department for forestry protection, national parks, or water, marine protection, pollution control department, or industry, mining, energy department. And even now, we are discussing whether we should have like the specialized climate change department. I think the minister, environmental minister, announced already that we should have this. Yeah, and not only the Thai, our domestic organs, but we try to work and collaborate well with our neighbors, our friends in our country, because we have like the same atmosphere. Like we have the same problem in our region. So we have, for example, like Asian Network for Wildlife Protection, and also now I think they are alert about the waste trade, international trade. Yeah. And about the justice agencies, so we have like in other countries also, we have police, we have public prosecutors, and about the court, we just have had the administrative court institution in the past, more than 100 and around 150 years, we have had only court of justice. So it's mean criminal and civil, labor, international trade court. But now, after 25 years, I think we have had administrative court system. So it was good that we separated the work so that the administrative law could be developed faster. However, sometimes when we work separately and the work is also overlapping, so sometimes we had problems about that, about the jurisprudence that, in different ways, something like that. And more than 20 years, we have talked and asked now whether we should have like specialized environmental bench or environmental court or not. And we set up environmental bench, firstly at the Supreme Court, and later in the 10 appeal courts around the country, and in the Central Civil Court in Bangkok. However, the idea to realize the environmental court cannot be complete yet, although we draft already the law to establish the environmental court, but our lawyer community we did not agree yet that we should have that. So it's like only the idea, and we try to work with other jurisdictions, like Justice Preston is like our mentor, so he came many times to Thailand, try to give us about the idea how the Green Court contributes to to the world and the planet. Yeah, and about the judgment enforcement agencies, we had like the ordinary system. So we have like execution department, probation or correction department, but we have not yet, the specialized office to the office to be responsible for cleanup case or something like that. However, I hope you can see and understand our system in the whole picture. Yeah, so now I'm talking in details about the problems and the cases that we have had in the court. So because we have biggest problem is the illegal logging and encroachment of the public land and the forest land. So you can see that we have many beautiful mountains, but now the trees were cut and no reforestation. And not only the problem with the trees, but the people or the villagers, and mostly they are very poor or some marginalized. For example, we have like many ethnic groups in the forest. So so how can we have like forest justice, and through our court jurisprudence? So I'd like to firstly mention or explain a little bit about the forest case, the timber and illegal logging and public law encroachment case. And many people call this situation or these kind of cases the global warming cases. Actually, it's not the climate change directly. It's like the public forest land, that has been encroached or illegal logging, which occurs every day and everywhere. So according to the international law, so we were active with the idea from the, our commitment from the Stockholm Declaration, or even the Biodiversity Convention, or many conventions and Thai law. So we have many, even only for the forest protection law, we have more than 10 acts, something like that. So I'd like to show the issues of these cases. So, should the public land encroacher or the timber cutter should be prosecuted or punished when they cut the tree? Yeah, actually you must say yes, no, because they cut the trees, no. But in practice, many, like poor villagers, they live sufficiently in their own community. So if they cut the tree, they might cut and then they plant the new one, something like that. Now, so it's like the traditional way of many Thai villagers. Yeah. So when they cut some trees and the police arrest them, how can we deal with this case now when we know that many people are very poor? However, they cut the tree. So according to the ecological justice, they must be prosecuted and punished because they cut the tree, they disturb the world, But in practice, many people around the country cut the trees, timber cutter or public enclosure. But, we have big problem with the discrimination in the criminal process. So it means the rich are not arrested, only the poor. So it's like many protests, poor or the arrested people said that, prison is only for the poor. So this is how can we deal with this, because many people must live in the forest, area, protected area. And about the distributive justice, the environment minister cannot do well to have a fair and just land distribution. So it means social injustice, and now we are dealing with social justice, injustice, and environmental injustice. So this is a big question that so many judges, even me myself, I did not choose to be back to the environmental law branch, division, because the sentencing guideline is too high, like a long imprisonment or, high big amount of criminal fine, something like that. So I think how can we apply the criminal law fairly, and equally to all classes of the people, something like that. And in the past, the people might be punished and went to prison, and that's fine. Later they came back home, and then they might be there again, So something like that. They were okay with that system. But later, when we introduced the civil liability law, so it means the people were not only prosecuted, but they were sue for the environmental damages, and this time, the public, the public park, national park department, though they made like a model, physical model to calculate the compensation, and they talk about the climate change damage, It's mean if you enclose 1 acre or 100 acre of forest land, you must automatically pay for some amount of money, and they said that, because you destroy the public land, and that's mean you made the temperature hotter than before, something like that. So it's the reason from the national park department or the forestry protection department, something like that. So the people hate hate the courts that we deliver this judgment on global warming cases. So it means the people must pay for the environmental damage also, and the total values of injury that we calculated was too high, So this is one example that I would like to show, that our judgments were criticized. And I would like to talk about more about the natural resources that we have. We are very rich, having wildlife in our forest. Pangolin, small animal in the forest. Now they sell pangolin, buy pangolin, not only 1, 2, 3, but it's mean 1 ton or 1 more, it's like a big amount, and not only in domestic market, but it's like the international market. So many pangolins were sent to China, and not only the international trade or domestic trade, but we have like kosher, maybe for their it's like sufficiently maybe they kill animals to eat, to have like food, but some for entertainment, for recreation. So one biggest case just happened 2-3 years ago. The big very rich man, he went with his group into the forest and killed the black tiger, the black panther. So the same, even we had like CITES instruments or Environmental Protection Act, and actually we have Wildlife Protection Act also, but we face that we have like bigger wildlife market, and many endangered species are living in Thailand, so we need to protect them. So the issues of the case should the illegal poacher be prosecuted or punished? Yeah, normally we can easily say yes also, but in details we have like you know, like small villager, poor villagers, and we have like rich people, and we have like a mafia or the kingpin, you know, like the intertrade, you know, so many different kind of the defenders, you know. So how can we do this well equally with these people, you know? And how much should they pay for the values of the wildlife? Yeah, and are there possibility? Is there possibility for the new breeding, for the new fertilizing, or you know, reproduction of this wildlife? Because some might be so endangered, and we cannot easily find them again in the forest, something like that. So I think this is like a conflict also between criminal and civil measures. Should we do these whole things together, and who is our target, or who you know? So I think the social injustice comes always with the environmental injustice. So what should we prioritize now, and which kind of legal legal measures that we should apply? Yeah, and so we have like street crime, and also we have like organized crime in this problem. So however, there should be no criminal or civil like impunity. Yeah, I would like to explain two more examples, two more cases. Yeah, so this is the problem with the marine pollution. You know, these are the same. This is only one beach, you know, but you can see the left one, very beautiful. I hope the Durham students can come and see our beach. Yeah, but sometimes, you know, the beach in the industry area in Rayong. This is in the economic zone, Eastern Economic Zone, Rayong province. So sometimes I think the corporate, they did not intentionally, did this thing, but they mostly negligently caused this pollution. So even we joined the UNCLOS or Marine Pollution Conventions. So I used to be a lawyer. As a young lawyer, I started my work at the Marine Harbor Department, you know. So I learned a lot about MAPO, about dumping convention or fund convention. So, and we, you know, we ratify every conventions, and we try to improve our law to the international standard. And we changed the Navigation in Thai Waters Act, and you know, so enough laws, enough legislation, you know? But how can we tackle the real problem? So this case is not only one case, no. I think 2 or 3 only in this area, you know. 2013, so a pipe connected to a tanker to an offshore pipeline owned by the PTT. This is the biggest, you know, company for the petroleum and, you know, global chemical. So the pipe broke and released some, you know, not some, but 42,000 liters of crude oil into the sea. And the level of, you know, of the poisoning always 200-300 times over the accepted standard, you know. Especially the mercury levels remain very high, and the contamination has spread to the other parts of the island. And later, 10 years later, so crude oil leaked from the undersea oil pipeline of the Star Petroleum refining. And the big amount of the spill oil also. And this impact directly the marine environment and the quality of seafood and also the tourism. So the question will also, should the corporates which leak the oil spill be prosecuted or punished? So they always say that it's not from human error, and not from outdated equipment. They said that they were ready always to tackle with the pollution problem. And so they always said that it was an accident. Mostly they say that it's due to bad weather, you know. So unfortunately that, you know, we did not, I mean, our legal system, our law enforcement did not think of the criminal law instrument, you know. They ignore that, and they always say that, oh, it's error from the bad weather, like that. So they talk only how much this corporate should pay. Yeah, and they try to have like a mediation process. Some succeeded, but some not, you know. And some cases were the people came to the court also, you know. So, and the problem is that which kind of legal measures that we should use? It's not all, it's only civil measures, or actually the administrative measures. We should have like the process from the beginning. I mean the you know, people participation or EIA process. Sometimes they ignore this kind of process, and even the people in that area did not know that they have like pipeline undersea near their communities, things like that, you know. So I think from these cases we learned that not only criminal civil measures should be enforced, but also criminal, and actually more importantly might be the administrative measures. So I come to the last case that I'd like to show. So it's like the problem of mining pollution, you know. I don't know whether Justice Preston know or not that many Australian, you know, corporate come to Thailand, you know, and try to invest and have biggest mining industry in Thailand. And for example, the right picture, you know, so you can see that this is, I think, the biggest site that we have had. And there was like a big scandal about corruption from the beginning, and also like there's no enough participation from the people, even the access to the information, something like that. And the people try to file a suit in the administrative court and try to stop the case, the permission. Yeah, so it's like the big war according to the mining law. And but another side, you know, you can see the left. The picture on the left hand side. So it's like this is only small creek, a small river in small community, you know. But you know, this case was like the landmark case, no? Because it was the first time that, you know, the poor people, and they were like Karen ethnic group. They are not you know, like real Thai, but I mean, they come from their own ethnic group, and they even many of them did not have the language ability to understand Thai. You know, they have their own language, and you know, and the problem from this case, the fact is that the residents of the creek, the lower Cedar Creek village, suffered the symptoms of the chronic lead poisoning, such as abdominal pain and headaches, and children born with severe developmental disabilities. Yeah, mostly like a mental health or mental disorder, something like that. So the lead released from a mine, small mine, but this killed many people, destroyed the ways of life of the community, and damaged the environmental severely. The voices of the marginal current villagers have not been heard for many years before they started to fight. Later, the media started to release news. Human rights activists went to the village and gave legal aid, and health personnel gave medical support. The villagers filed 3 suits in the administrative court and the provincial court against the Pollution Control Department, the PCD, and the mining company. Finally, the Supreme Administrative Court and the Supreme Court ruled that the PCD and the company must pay for the personal injuries and the creek must be cleaned up. During the court cases, the company paid for the criminal fine. You can see this might killed many people and made many people disability, but the officer applied only one act. There are many acts related to these offenses, but they applied only one act, and the company paid only $50 and that's all. So there's like they use small things. They can have like big sort of criminal law before, but they did not use that, and the license was cancelled. But it's not automatically or fast cancel, but it because of the people try to request very long time until the officer heard their voice and then they did it. So however, these three cases were the landmark environmental cases of Thailand. Although they won to the highest court of Thailand, the government and the company still have failed despite court orders. So you can see that from these landmark cases, biggest problem is that who were the polluters. Normally the corporate discharge the polluted water, they must be polluter. But in Thailand, according to our system right now, the PCD, the Pollution Control Department, was the polluter, and the administrative court ruled that they must pay because they ignore to clean up in time, something like that. So we have like, normally they must be our hero and they must, enforce the law, against the polluter, but they are called polluter also. And what happened next, so it means they need to clean up and they use our tax, So I call these cases, not only these three cases, but many cases are in the same pattern. So that the PCD was like the defendant, they was sued for the money. So I call this the government pays principle. It's not the polluter, the direct polluter pays principle, but it's a government department which did not do their task well, and they were polluter. They were polluter, and they must be liable for this money. So this is like so I think multiple use of administrative law, criminal law, and civil measures. It's good, but how can we do it appropriately? So in conclusion, I think we have like overlapping tension of these legal instruments, and I'd like to show you 3 points. So I think biggest problem is the problem of proportionality. We don't know what's the meaning of the real and good proportionality. So sometimes you can see that we apply the measures too much, but sometimes too little, So I think we need to understand and prioritize the different instruments properly. And to understand this, I think we need to study the basic legal principles and philosophy of each process. Otherwise, we cannot have the environmental rule of law, So multiple enforcement of all legal instruments should be proportionate and adequate to induce compliance and lead to deterrence. So I think from my point of view, the administrative law instruments is the instrument. They are these preventive and precautionary measures should be strictly applied, especially to the large-scale project or dangerous projects. Yeah, and important measures such as zoning measures or setting new standard or something like that should be more introduced. Yeah, it's still, I think the officers, environmental officers in Thailand did not understand how well about their administrative power. Even as I told you, I was in the harbor department. We issue the license, many license, but our officer said that, oh, we cannot easily, revoke the license. Now we don't have the power to license. Many officers still misunderstand about their own power. So I think that we need to make them understand well about their weapons and how, especially the administrative instrument. Yeah, and about the civil law instrument or financial instruments. Yeah, I think the compensation for nature, the depleted nature should be used for the real restoration and remediation. So many, a big amount that the court, from our judgment that we have like in the civil case, the people must pay for this compensation, but the money went back to the fiscal fund. No, it's not did not go directly for the real restoration and or remediation. So I think we need to develop our system to to heal the nature. Yeah, and some legislation we have already the punitive damage. For example, the new Mining Act. When the corporate did something wrong intentionally or gross negligence, they might pay triple times for the punitive damage. But no one in practice could understand well about this. Now, how can we ask for the punitive damage? How can we double or triple, in which conditions, something like that. So, and also about the PPP, polluter pays principle. So, yeah, as I told you, we need to identify who is the real polluter, and our system must identify that correctly. Yeah, and about the criminal law instruments. So I think if it's not necessary, so we don't need to use criminal law instrument, but actually in our criminal code or law acts, many acts, so we have like criminal law punishment. So I think we need to identify what should be like administrative fine or which should be like criminal fine, something like that. Yeah, and we need to identify which kind of crime. We have street crime or organized crime, domestic crime or transnational crime. So sometimes we see like a small picture in our trial room, but we did not know what is a big picture. Yeah, that the people in our case related to other people or other cases. So I think so many people who work on wildlife protection complain Thai judiciary that we have like we did not set the punishment too low imprisonment or fine, because we saw all posture like only street crime category, something like that. And now our penal code introduced the restorative justice process. Yeah, and we never use this in environmental law. So in minor offenses, actually we should have more active restorative justice programs, but until now nothing happened. So I think in criminal legal factors. Yeah, we need to develop many things to use this criminal instrument properly. And as I told you, corporate crime must be considered. In the past, when juristic person, committed crime, so we had only criminal fine, but actually director or engineer can be imprisoned right now if they are the real actor in their corporate, something like that. So I think many things that we should try to develop in our system, serious impact and consequence now to the nature. Yeah, they must be. Yeah, anyone who did this must be criminalized. Must be punished, and reoffending must be highly punished also. So not only this the first problem, but the second problem is that I think the problem of the different in environmental ethics, because some people respect the ecological justice, try to increase the right of the nature, because the nature is the voiceless, especially like climate justice. We need to do everything to tackle the climate change problem. However, we cannot ignore the social justice, because we still have like a different the problem of inequality in our social inequality, and not only in Thailand, but maybe Thailand with other neighbors also, other countries. Yeah, and in our domestic community, we have big problem between the rich people and the poor people. We also have problem with the people in the like ethnic group, minority, something like that, and even the age, about the intergenerational justice, something like that. I think we should talk more about this further and try to have balance. And the last one, last point that I would like to focus is on the domestic enforcement is not enough. Yeah, because as you can see, I think we try to develop our own system, but I think we get lost sometimes, because we try to learn from the UK system, from the US, from Australian system, but sometimes we love to have everything in our hands, but it's impossible. And we don't know how to use these things well together. So I think you cannot, if you if you were the UNEP executive director, what would you do with us? I think I show you some examples, some problems already. I think you might give us some recommendation. What would you plan to do with us? What I would like to say is that domestic enforcement is not enough, and domestic lawyers are not ready enough to tackle our problems. And actually environmental problems are not our problem in our country, so I think we need your hands, the foreign hands, to help us too. So I think what I have talked, I would like to raise awareness of the global community, that the international organization, you try to set standard, for climate change, for biodiversity, for marine, quality, something like that. But maybe you must pay attention how every country understand well about these kind of legal instruments. So I think you must see the big picture, and you must equip us, equip everyone in the world to understand these important legal instruments and work well, how can we say, harmonize, and understand the same ethics, philosophy, and then the same practice. Yeah. So I think many countries cannot solve their own problem. So we need to share more information, especially the judicial decisions. Yeah, and we must exchange our real practices. Yeah, in order to achieve this, we might have like a set academy, like our senior friends try to set up the judicial institute, global judicial institute for environment. I think we need to work and collaborate very intensively to expand the ideas, for all lawyers around the world. And especially maybe if I can recommend, maybe we need to draft a model law setting this multiple use of these 3 legal instruments and set, new common norms and practice. Yeah, and draft the new court model. Yeah, interdiscipline problem solving court. And I think, so I end up my lecture right now, and yeah, I give you some references, so maybe you can have some more details, some ideas from these websites, and if you would like to have anything more information or anything, or even some student would like to come to Thailand to see me, see our country, and then so I would love to see you all, and I am happy to work with you intensively in the near future. Thank you very much. Thank you.
Thank you so much, Justice Muanpawong. It's been an amazing lecture, very insightful, and you've got an admirable knowledge on these intersections between the different instruments. So I've learned a lot, and I'm sure the students will have learned a lot, and those who will watch the recordings later. So thanks again very much. There are 2 questions in the Q&A session, so I will ask those first, but I've got also questions, but we will also make sure we are not going to overstretch your time. We are very aware that, we are very grateful for your time already. So there's one question here from the audience, and it reads as follows. So terms such as green, natural, and sustainable often appear when promoting supposedly green businesses and their products and environmental agreements. They seem to be connected to the occurrence of greenwashing and malpractice. How much legal weight do the definitions of these terms actually hold? And then, in your opinion, how should they be viewed by legal systems, international and domestic, in order to hold companies, governments accountable?
Yeah, thank you. Thank you for the difficult question. I don't think it's easy to answer your question. However, it's great that you have this remark. I think I would like to come back to the environmental ethics, no? Yeah, because I think Professor Petra Minnerop might know that when we talk about the environmental ethics, we have maybe many approaches, but the main 2 approaches are very important, because firstly is about the human-centric approach. Yeah, so when we talk about environment, but it's like something that serves your life. So it's like environmental service. It's service for you, something like for human. So this is like we are in the center of the environment. So you asked about the definition. So this is the interesting topic that I sometimes teach my students also, because according to Thai Environmental Protection Act, the definition, environment means the thing, organic and non-organic, around human. This is a Thai definition. But I studied. I learned. I read the good model from Canadian Environmental Protection Act also. According to the Canadian version, environment is organic and non-organic things. And the human and the environment and the relationship between these things. So the human is not in the middle. So this is human-centric approach. So when we talk about the climate change, so many people are very, very worried now. Oh, how can we survive now when the temperature is higher and higher? So we need to get rid of all problems because we must survive. If you do this for this purpose, you have human-centric approach. So, and if you have like a ecological approach, eco-centric approach, it means we do everything to protect our planet, our environment, our ecology, our climate for their sake. I don't know how to say it. It's not only for us, but for everything, not for the Gaia, it's not for we talk about Homo sapiens, and my friend wrote a book on Homo Gaia, So it's like we protect the ecology, because we need to protect the ecology. It's not because of us. So I think there are many different levels to be green, Many engineers said that, oh, we have a clean technology, environmental engineer, green engineer said, oh, we produce green technology. So the deep ecologists ask the engineer, oh, we don't want a cleaner technology. We would like to stop using technology, something like that. No? Some group try to produce greener and greener things. But some people said that, okay, turn off the electricity. We can stay dark in the nighttime, something like that. So I think your question, so come back to the heart of the legal, I don't know, not legal, but environmental philosophy. What is your stance? You can be like only like a green business. Many green business in Thailand, so they stop using plastic bag, and they say that they are already green. But we can do something more to be greener and greener. So I think you must come back to the heart of the philosophy, and you can understand which way you would like to be people, human-centric, anthropocentric, or ecological-centric. Thank you.
Thank you very much for the very comprehensive answer. And there's a second question, and I think you probably already, and the person who asked the question also thanks you for the response just now. I can see that in the chat. So there's a second question that is asking, do you have any recommendations for reading a starting point for some of the topics you covered today? So you've already given us this list of reading. So do you want to add to that? Or?
Yeah, actually, I love to hear your ideas. Maybe I would ask some volunteers to write some ideas for me. I'd like to know if you were the UN UNEP executive director, what would you do first after you listen to my lecture?
Yes.
So
maybe we can have a response on that question, because we haven't had that yet, and we will give the audience a chance to type something in on that. But maybe in that time I can ask my questions, and if nobody is brave enough to ask as UNEP executive director, then we will accept that as well, of course. But I found this comparative legal analysis really interesting, where you said you're almost using legal transplants from different jurisdictions and use that in your legislative process. And I was wondering to which extent does this also entail that you are using certain jurisprudence that comes with it? So do you use the jurisprudence on certain aspect of that law that you may have used to also develop your own jurisprudence in courts? So do you use this kind of same comparative approach where you say we are looking into how have certain administrative courts interpreted this part of the administrative act, for example, or how do you mentioned now the German differentiation, for example, between tort law and nuisance law? Do you look into the jurisprudence around these aspects as well and include these into your legal framework?
Yeah, I think so. We have like separated power now between administrative court and the Court of Justice. So sometimes we look only in our jurisdiction, our legal measures, and yeah, we try to find the best solution for the cases. Yeah. However, I think the problem is not only our job in the trial room, but we need to understand the bigger picture. Sorry, I need to. Okay, sorry. So I think if, for example, if the judges don't recognize the social injustice in our Thai communities, so how can we give a fair judgment to the poor people if we don't see the problem of discrimination from the upstream criminal justice process? Yeah, as the poor protested, the prison is only for the poor, because from the beginning, only the poor were arrested. Many, big guys, high-ranking officials, or mafia, or maybe MPs, or they were ignored. So only. I don't mean only, but I mean mostly, it's like a discrimination happens in our system. So how can we do and deliver justice, like individualization of justice, each case by case. So I think if we have good background and ideas, knowledge about social injustice, and we try to produce more alternative ways. For example, we can set like a probational measures, but we had no ideas about the probation, process, something like that. So I think we need to work in detail. So I call this like sensitized justice system. So sensitize means you have to sensitize our members that what happened in our country, and then what happened with our case when the people cannot have like the land title deed because the problem come from the land department. So maybe they live in the forest, but actually they have lived more than 100 years. Actually, they are entitled to get the land title deed, but they did not get yet. So they will call public land encroacher, something like that. Yeah, and these poor people, when you apply the criminal law, it's already serious enough. But you apply the civil law also, fiscal things, financial measure. So sometimes it's good if you punish the rich corporate because they earn a lot from like non-compliance profit. Yeah, if you are facing these people, you must use all instruments. But when you see like small people, how can you try to have a troop and fight against them? So I think this is injustice in our system that we have.
Thank you again so much. We don't have any answers to your main question at the beginning, and that is an indication that we need further discussions around this. So I would like to end today with a suggestion that maybe we take forward this idea of closer collaboration between the judiciary in Thailand, but also through the Global Judicial Institute on the Environment and the Durham Center for Sustainable Development Law and Policy, because we've got a lot of interdisciplinary research, but also questions that could really benefit from the inputs from the judiciary and your experiences. So I would really like to keep this closer ties growing and to maybe welcome you to Durham very soon. And there are no further questions. So I would like to again thank you so much for your willingness to contribute to the series, for a fantastic lecture and your dedication in answering all these questions. So thank you again very much.
Thank you very much. Goodbye. I hope to see you all soon in Thailand. Bye bye. Thank you.
Thank you. Bye.